the queries of the Integrity Commission to provide clarification on the issues that arose. So we have had an investigation for over 5 years. I would say due process was provided to Dr. Wheatley over this period of time. And beyond the allegations, I want to look at the issue of his own credibility in the responses that he has provided to the Integrity Commission, because it goes to the heart of public trust. And I believe, based on the responses he has provided, he has lost public trust and credibility. And just on that basis, he should be removed from the cabinet. Let me take one of the findings from the Integrity Commission. The Integrity Commission asked Dr. Wheatley to provide information about the sale of his medical practice, Western Medical Center, for $13 million in 2013, which was paid through intermittent cash payments. Dr. Wheatley named the buyer, but he produced no receipts. The Integrity Commission independently established that the individual who was named as the buyer had been involuntarily removed from Jamaica, whether by deportation or extradition, 3 years before the transaction was allegedly to have taken place. Let me just repeat that. Dr. Wheatley said to the Integrity Commission that his medical practice was sold to an individual. He couldn't provide records. When the Integrity Commission did its own research, the name of the person he provided had been removed from Jamaica, either by deportation or extradition, 3 years before the transaction was alleged to have taken place. So that explanation was not just unsubstantiated. It was impossible. It could not have taken place. And the Integrity Commission rejected that. Let's take another issue that arose from the report. An investment scheme. Dr. Wheatley told the Commission he earned returns from a high-yield investment scheme called U-Win Antigua between 2007 and 2010. The Integrity Commission could find no evidence that this scheme existed. There were no records. But more importantly, the explanation or the records were not in Dr. Wheatley's own statutory declarations for the entire period. And he only raised this in 2024 when the issue, part of the investigation into illicit enrichment. So there is again an issue of credibility. Dr. Wheatley represents to the Commission one thing, and then on investigation, it is found that it is totally opposite. The third issue, Dr. Wheatley had indicated to the Commission that he had received rental income of approximately $143 million. Naturally, the Integrity Commission asked for the names of those tenants, receipts, etc. Dr. Wheatley said that those persons were protected under the Data Protection Act, and as such, he could not provide that information. When he was pressed further, while he was able to provide some names and some substantiation, he could not substantiate the entire amount of $143 million, which he claimed came from rental income. The fourth issue relates to commercial loans, that 5 Bank of Nova Scotia loans were taken out in Dr. Wheatley's name, spanning over the period 2013 to 2021. But these were never ever declared in his statutory declarations. His explanation was that these commercial loans were related to a joint venture with a business partner and didn't involve personal finances. But that was rejected by the Integrity Commission, because once a loan is taken out in your personal name, you are required to declare that to the Integrity Commission. So again, a very clear and I would say deliberate omission. The fifth issue relates to his ownership of lands in East Kirkland Heights, which were subdivided into 20 strata lots. 14 of those were sold over a 4-year period. None of this was reflected in his statutory declarations of 2013, 2014, 2015, or 2016. 6 of the lots were transferred to him solely. It wasn't until 2017 that any reference to a subdivision appeared at all. The Commission obtained the full picture through information from the National Land Agency, independent of the information that would have been provided by Dr. Wheatley. Again, this is not just a matter of an oversight. These are sales from assets that he would have had, which he would have been required to declare to the Integrity Commission, which were not done. The sixth issue is that when you look at the totality of the chronology of the events related to the investigation into Dr. Wheatley from 2021 to 2026, there is a pattern. There's a pattern of information that is not readily provided. There's a pattern of information that is provided which cannot be substantiated. And there's really a pattern of evasion. Now, anyone who operates like this, whose own credibility cannot stand the test of scrutiny, should not be a member of a cabinet. And so, in closing, we are reiterating our call for Dr. Wheatley to be removed immediately from the cabinet. I find it ironic. He was removed in 2018 after allegations of corruption, nepotism, and cronyism related to him as Minister of Energy. For some reason, he remained out of the cabinet for 7 years. Now, I don't know whether he told the Prime Minister when he was being reappointed that he was the subject of an Integrity Commission investigation into illicit enrichment. But one wonders, why would he have been reappointed if he would have known that he was the subject of an investigation? And the question has to arise. I mean, we know he's not alone. We know there are at least, from my count, 8 or 9 others, members of Parliament, we don't know whether they are cabinet ministers or not, who are also the subject of investigation by the Integrity Commission for illicit enrichment. We call for those persons to declare themselves and hold up their hands, because we can't have the executive of the country dominated by people who are under investigation for serious criminal corruption. Corruption meaning having illicit enrichment means you have assets that you cannot account for based on your lawful income. The country has to draw a line in the sand, and the PNP is resolute, and we will continue to hold this government accountable and ensure that persons with that kind of track record don't have the opportunity to exercise decisions over this population. I'm going to stop here and turn to my colleague Cleveland, who will take us through some of the findings of the Integrity Commission related to the finances that were exposed. Cleveland.
Thank you, Julian. Good afternoon to the members of the media and Jamaicans watching online. The offense of illicit enrichment was enacted in domestic law in 2001, pursuant to Jamaica acceding to the Inter-American Convention Against Corruption. Article 9 of that convention requires that states that accede to the convention should recognize in its domestic law the act of illicit enrichment, which is treated as an act of corruption. Illicit enrichment, in essence, speaks to the enjoyment of a particular degree of wealth that cannot be justified, that cannot be traced back to, that cannot be linked or referenced to one's lawful legal source of income. The Integrity Commission, having conducted its extensive and thorough investigation, concluded that Member of Parliament, Dr. Andrew Wheatley, is in breach of the Corruption Prevention Act, in particular, the offense of illicit enrichment. How did it arrive at this conclusion? According to the Integrity Commission, between 2013 and 2022, Dr. Wheatley, his total known lawful income amounted to approximately $187 million. His total expenditure and assets acquired over that period, over the same period, amounted to approximately $352 million. That's a shortfall of $164 million. So how you arrive at illicit enrichment, the determination of illicit enrichment, a formula, a simple mathematical formula is incorporated. Let's assume that your wealth over a period of time amounts to $20. The assets that you have acquired, the expenditure that you have made was $20. But your income over that specified period was $10. So you deduct your income of $10 from your expenditure or your wealth of $20, which would leave a difference of $10. That $10 cannot be explained by your lawful income, which means that that $10 is treated as illicit enrichment. In the case of Dr. Wheatley, it was not $10, it was $164 million. So $164 million of his wealth could not be explained by his lawful income. And that is why the Integrity Commission concluded that this amounts to illicit enrichment. Make no mistake, the Integrity Commission provided numerous opportunities for Dr. Wheatley to explain the source of this wealth. I read the chronology, I read the report in its entirety. There were several opportunities for him to appear before the Integrity Commission in the presence of his counsel to explain and justify his source of income. So he cannot provide an explanation that he did not have the opportunity to respond. The Integrity Commission was very extensive in the opportunities that it provided him. The findings are more serious than just the $164 million of his wealth that could not be explained by his lawful income. There were bank deposits that also could not be explained. According to the Integrity Commission's report, total deposits across his 4 personal accounts for the relevant period amounted to approximately $595 million. After accounting for transfers, interest, and deposits that carried a satisfactory explanation, the Integrity Commission was satisfied with the explanation provided for that. Approximately $168 million remain unexplained. In essence, deposits to his 4 bank accounts amounted to $168 million that could not be explained. Where have we seen this before? We have seen it when the Integrity Commission produced its report into the financial conduct of the Prime Minister and his personal financial affairs, where we saw that there were deposits to the tune of millions of Jamaican dollars that could not be explained. It's the same pattern that is emerging in this situation with Dr. Andrew Wheatley. There are also vehicle sales that could not be properly substantiated. Dr. Wheatley claimed $29 million from the sale of vehicles. The Director of Investigation was able to independently verify the sale of only 4 of the 6 vehicles claimed. No documentary evidence of sale prices was produced for any of them. That is problematic, and this contributed to the conclusion from the Integrity Commission that something was not right with the conduct of his financial affairs. Let's also look at rental income. Dr. Wheatley reported approximately $143 million in rental income over the period. When he was formally requested to provide the tenants' names, the lease agreements, and bank deposits evidence, he initially refused. Now, if you are on a mission to clear your name, I don't understand why it would be difficult for you to produce the information necessary to act as evidence in your defense. So he initially refused, citing the Data Protection Act. And the Director of Investigation determined that argument had no legal basis whatsoever under the Integrity Commission Act. Only a portion of the rental income was ultimately substantiated. So the remainder was excluded from the calculations. And that acted in his favor, understand that. But beyond that, there were undeclared loans, commercial loans. There were loans from Bank of Nova Scotia that amounted to over 50 million Jamaican dollars that was not declared in his statutory declarations. That is a breach of the Integrity Commission Act that requires for you to completely and accurately disclose all assets and liabilities and income. And a loan is a liability. You owe it. You're supposed to pay it back. And he did not disclose that. And when I calculated the amount, it was over $50 million. I don't know how you can forget that you owe over $50 million. You know, that's unheard of. So the Integrity Commission found that to be very problematic. There was also the acquisition of land, the East Kirkland Heights development. Dr. Wheatley co-purchased land at East Kirkland Heights in 2011. The land was subdivided into 20 strata lots in 2013. 14 of those lots were sold between 2014 and 2018. None of those transactions, or not one of those transactions, appeared in his statutory declarations. The Integrity Commission requires that you include disposal and acquisition of assets in your statutory declaration. He excluded that, and this contributed to the conclusion that he omitted information required from his statutory declarations. There were 6 remaining lots that were transferred to him solely as purported gift from this joint venture. So what the Integrity Commission identified is that, according to him, he did not invest any capital in the acquisition of this land that was subsequently developed into strata lots. But then he received 6 lots as gift, and that sounds highly irregular. And in the absence of evidence to substantiate his claim, the Integrity Commission dismissed his explanation. You know, in closing, I want to say that the methodology that was utilized by the Integrity Commission in arriving at illicit enrichment is robust. It's not only utilized in the Jamaican jurisdiction, it's utilized across the world. And it's a simple and easy formula to utilize, and that it resulted in a significant amount, $164 million, being unexplained by his lawful earnings is serious accusation. And I repeat the call from your position that with this hovering him, he has no place in the cabinet of Jamaica. The office of cabinet, the public office, exceeds any individual and must be treated with the appropriate dignity and respect that he deserves. He should step aside forthwith.
Thank you. Thank you, colleagues. Thank you, members of the media, for being here, and those who are watching online. Greetings. My 2 parliamentary colleagues have gone into some of the details of the Integrity Commission report concerning MP Andrew Wheatley, who is a minister of government. As a result of that extensive investigation done by the Integrity Commission, the Director of Corruption Prosecutions has made a decision that Dr. Wheatley should be charged with 4 offenses. The most egregious of those offenses is the corruption offense of illicit enrichment, which is part of our law, was brought into our law under the Corruption Prevention Act to give effect to our international obligations as signatories to anti-corruption treaties, which are global. It is absolutely untenable for the Cabinet of Jamaica to have a sitting minister who has been recommended to be charged with the corruption offense of illicit enrichment. That brings Jamaica's name into disrepute, both here and abroad. Furthermore, there are 2 serious charges relating to making false declarations, which is also a serious offense under the Integrity Commission Act and its predecessor, the Parliamentarian Integrity of Members Act. That prior to 18 was the law which required MPs and senators to file annual declarations. And it's important to note that what the Integrity Commission is saying is that the falsehoods in the declaration submitted by Dr. Wheatley arose both under the law prior to 2018, the Parliamentary Members Integrity Act, and the law that's existed since 2018, which is the Integrity Commission Act. So there is a long-standing pattern of these declarations not giving the true picture of the members' state of affairs. It's a statutory declaration is a comprehensive document. It requires you to disclose all your assets, personal or business, all your liabilities, personal or business, and all your income. Dr. Wheatley, manifestly, according to the report, didn't comply with those obligations, hence the recommendation that he be charged. And there is a fourth offense relating to failure to supply information required by the Commission, which is also a serious offense. So I am reiterating my call on Andrew Holness, the Prime Minister of this country, to take the necessary steps to ensure that Dr. Wheatley is immediately removed from the Cabinet of Jamaica. It is true that Dr. Holness himself remains under a cloud because his declarations were the subject of a detailed report, and the findings were sent to the FID over a year ago for them to investigate further because information that the Integrity Commission had asked for had not been provided, which was necessary for them to conclude their work. That remains in abeyance. Dr. Holness took the Integrity Commission to court, seeking to challenge the constitutionality of that legislation, the Integrity Commission Act itself, which was passed by his government, and also the offense of illicit enrichment, which is in the Corruption Prevention Act, and which is an important part of our anti-corruption architecture. This is the context in which we're operating in this country in terms of governance, and it cannot be worsened by having somebody who's under the cloud of a criminal charge pending for serious matters like this being allowed to remain in the cabinet of the country, which is the body in charge of the executive government of Jamaica. So we have called for this, and we hope that all well-thinking Jamaicans and all organizations that have an interest in national development and the good governance of the country will put some pressure on the government so that the right thing can be done. We don't know the outcome of any prosecution. That's not for us to determine. The point is, whatever Dr. Wheatley may be saying in his defense is really irrelevant at this point. The investigation is concluded, a decision has been made, he is to be prosecuted for these matters, he must step back. He cannot remain part of the government of Jamaica. There are two other matters I wish to raise with you today. The first of those two relates to this matter of the third country nationals who are going to be coming to Jamaica pursuant to an MOU that we were told in Parliament yesterday by the Minister of National Security, Dr. Horace Chang, was signed by him, I believe, on behalf of the government of Jamaica last week, Thursday. Now, this is a matter which is of great concern to many Jamaicans. The US courts have the lawfulness of these arrangements in their sights currently. There's a case decided by a federal judge in Massachusetts which said that these third country arrangements are not lawful under US law. The government of the United States is appealing that to their Supreme Court. That matter is not yet resolved. But we are nevertheless embarking upon an arrangement, notwithstanding the fact that the lawfulness of that arrangement in the jurisdiction of the other country that we're signing to is itself very uncertain. But there's another matter which I think cannot be overlooked. The Gleaner has reported that they received a copy of a diplomatic note from the United States government to the Jamaican government indicating that this arrangement was first proposed by a member of the government of Jamaica, Audrey Marks, MP, and that she raised it in March, I think it was, at the security conference that was held in Florida, hosted by the US government at the time. In Parliament yesterday, Dr. Chang was asked the question, how did this arrangement come into existence? And he said that it was initiated by the US government. Now, the two positions can't both be true. And I think there is a basis for this matter to be referred to the Privileges Committee of Parliament so that the question of whether the Minister of National Security lied to Parliament yesterday can be looked into and investigated and dealt with appropriately. And I'm calling for that to be done, because we cannot have a situation where ministers of government in Parliament on their feet answering questions about matters of state are not being scrupulously truthful to the public in Parliament. The last issue I wanted to address today relates to the squabble that took place during the proceedings of Parliament yesterday, and which have been covered by at least one media house, and I believe in social media, alleging that, or saying that the Prime Minister was calling a member on our side a bully, and so on. Now, for those of us who were in Parliament and who witnessed this, it's quite clear that the squabble began when the Prime Minister told that member to shut up. Twice. When the member responded and said, "What did you say?" He repeated it and told him to shut up. This was in the context of the member speaking to the question of Hansard, being asked to verify what had been said previously in the same proceedings, which were the subject of a dispute. It is